මම මේ වැඩිය background එකක් දෙන්න නැතුව I'll jump into the syllabus itself. Why? Because see, admin law කියන විෂය is a very complicated subject, right? It is complicated because we haven't understood the subject very well. That's why. Otherwise, admin law is one of the most practical, one of the most easiest subjects ever. Okay? So when I wrote the exam, not long ago, this is last year, not that I'm, this pundit on like admin law or whatever, but I definitely do know the shortcuts to like get the marks you want and also to go for a good grade, right? But I should tell you one thing, admin law කියන විෂය මේ අන්තිම දවස් දෙක තුන පාඩම් කරලා කරන්න පුළුවන්. හැබැයි හොඳ thorough understanding එකක් ගන්න නම් it's better that you start early. Because when I did the obligations one කියන්නේ contract law copy කරන මං කිව්වේ ප්‍රශ්න නැහැ දවස් දෙකකින් දවස් තුනෙන් පාඩම් කරන්න පුළුවන් if you're that desperate. But admin law, I advise everyone to be familiar with the subject. That's number one. Number two is that in admin law අපි දැන් සාමාන්‍ය විෂයන් කරනකොට අපි we choose and pick certain areas. සමහර අපි area එකක් කරලාගෙන හරි මේකෙන් තුනක් that's okay. මේකෙන් තුනක් අපිට cover කරගන්න පුළුවන්, right? Or we combine two areas so that we know that definitely මේ ගාන questions එනවා කියලා. Now the problem with admin law is every single question is connected to another, right? Because admin law කියන්නේ හරිම that's again why people find it very complicated because හැමදේම is related, it's connected to one another. So when you get the question paper, first question එක කියවුවම දැන් ඔයාලට දැන් සෑහෙන જાති ඔළුවට එයි, right? Because අපි we are used to look at a problem එක විදියට. Now if it's judicial review නම් අපි පාඩම් කරලා තියෙන්නේ අපිට judicial review වලට එන content එක විතරයි ඔළුවට එන්නේ ප්‍රශ්නයක් දැක්කම, right? But in admin law what happens is the questions are designed in such a way that certain elements of the question would make you want to think about like other aspects of admin law. So the judicial review කියලා පාඩම් කරපු answer එක හැමෙම ලියන්න බෑ දන, right? Hence why you need to be really thorough with the content. Having said that, right, this is my motto to life. If you want to be or if you want to understand something, start looking at it in a more simple way, like life. Hari? So admin law කියන විෂය don't go to like memorize it, don't go to by heart it, even though it sounds or it looks as if content worthy of by hearting or worthy of memorizing. Don't go to do that. හැමදේම හරි practical විදිහට බලන්න because admin law is again one of the most practical subjects ever. Okay, so we'll start with a bit of theory, right? We'll start with theory and move on to like the practical aspects of admin law. Hari, so උදේ introduction එකේ admin law කියන්නේ මොකක්ද කියලා අහනවානේ, right? ඕක මම හිතන්නේ ප්‍රශ්න කරන්න නම් ඒ කියලා මේ admin law කියන්නේ මොකක්ද කියලා. But it's always good to know. So you can give like three interpretations to this, right? First of all, you can say that this is a body of principles which govern the exercise of power, duties of public authorities. Now, what are public authorities? Anyone know what a public authority is? I'm sure you all know, but sorry? There we go. So, public authorities are, as he said, state-recognized organs, right? These are government bodies who, they are established to make sure certain elements or certain functions of the government are properly and duly exercised. That's why they're there. Hence, why it's very important that there are certain principles, right? Or certain instruments or certain framework of justice or framework of doing things to make sure that දැන් ඒගොල්ලන්ට බාර දීලා තියෙන වැඩේ හරියට කරනවද සහ ඒක කියන්නේ unduly ඒගොල්ලෝ ඒක use කරනවද කියලා. ඒ power එක තමන්ට තියෙන. And hence why admin law is there. Simple, right? So ඒක තමයි කියන්නේ public authorities derive power from acts of parliament or constitution and perform their duties towards public. That's the definition for a public authority. And so coming back to what admin law is, admin law can principles created a code of conduct for public authorities, and if decisions or actions taken in violation of these principles, court is empowered to declare them null and void. So basically අපි වෙනුවෙන් තියෙන public authorities හරි ඒගොල්ලෝගේ power එක අයිති විදිහට ප්‍රයෝජන ගන්නවා නම් if they are unduly exercising their powers, courts would intervene and be like, look here, these are the powers you have. This is a framework you need to be in. Stick to it. So whatever they have done, they would make it null and void. Okay? So now හැමෝටම idea තියෙන මොකද්ද admin law කියලා කියන්නේ කියලා. Right. Having said that, okay, I'm just going to brush through all of this, right? Okay, sources of admin law. Now, අපේ ලංකාවේ නීතියේ මූලාශ්‍ර මොනවාද? Constitution. So admin law වල මූලාශ්‍රයක් තමයි constitution එක කියන්නේ. හරි? ඊට පස්සේ තව මොනවද තියෙන්නේ? We have judge made law. Right? We also have English courts making law for not for us, but they make their own law. That's precedents. Right? Yeah. So අපිට ඒතර ඒකෙත් influence එකක් තියෙනවා. And then also the statutory provisions. Right? So technically admin law කියන්නේ මේ alien concept එකක් නෙමෙයි. It's not, something that is so like, not gibberish. Basically, සාමාන්‍ය දෙයක්. නිකන් ලොකු කරලා අපි තින් කතා කරනවා because why? We need to show that we know something, no? Right? So ඒකයි like, in the paper you write නිකන් වැල්වට අරන් ගොඩාක් ලියනවා, but it's the concept, the principle is very simple. Okay, so the constitution, the main source as provide fundamental framework for governance of this country. That is the constitution. There's article 140 of the constitution. Make 140 constitution 140 article එකකින් තමයි powers දෙන්නේ to the courts to intervene or to make it null and void whenever these authorities act out of their powers or rather the framework given to them. And statutory provisions, which are like statutes passed by the parliament and etc. Then there's English common law. So like you'll get to know this case of Wednesbury unreasonableness කතාරන්නේ, and then again තමයි මේ ඔය ඔක්කොම අර dichotomy එක හැදෙන්නේ ඒ case එකේ. So these cases they were decided in England, but it has like precedence and like influence over Sri Lankan law. And then of course Sri Lankan judge made law. I'm sure that you all have heard this case of Peter Athapattu versus People's Bank. For something else also, මට හරියට මතක නැහැ subject එක මොකක්ද කියලා, but it's there and it's very important in admin law as well. Right. And then okay, so we also like that's like the basic knowledge you need to have as to what admin law is. Then එක topic එකකට එනවා අපි දැන් writ එකක් කියන දේ දන්නවා. writ ආඥාවක් කියන්නේ. writ එකක්. Right. So there are writs. Certiorari, mandamus, co-warrantos, those are writs, right? Prohibitions, yes. And there are also things that are similar to writs, but not writs. Orders similar to writs. See, now I would love to do this, make a local question, it's a very small area. So I actually prefer going to judicial review and substantive ultra virus පැත්තට ගිහිල්ලා will come to this වෙලාව තිබ්බොත්, because I mean that's where the bulk of your paper would be from the doctrine of ultra virus. Hari? Substantive and the procedural aspect of it. ඒ තමයි proportionality, එතකොට procedural impropriety ඒ ඔක්කොම තියෙනවා. So that's like a chunk of your syllabus. So අපි ඒක කලින් කරලා you come to this. Is that okay? or පිළිවෙලටම යන්න ඕනේද? No, other way. Okay. Right. Okay, so before that, one small thing. There are certain provisions in the constitution. No, we'll come to that later. Nothing confusing. No. So we'll go to doctrine of ultra-virus, right? Do you all have these slides? Nah, neither. Can I see just to see whether it's the same slides? I'm so sorry. Thank you. එකම slides එක නෙවෙයි, but almost I mean the same content. Right. So, as I said before, Parliament confers certain authority and powers to public bodies. Now, what are public bodies? What are public bodies? You all know this for sure. I mean, see, we can talk එහෙම මේ ප්‍රශ්නයක් නැහැ මේ so කියන්න otherwise I mean we can just pause the lecture or the kupiya until we come to like consensus that we will talk. So what are public bodies? So departments, right? Then ministries, certain now even schools sometimes, right? Sometimes, all the time. And like basically whenever the government has an involvement in something, you can recognize that it has a public body. The simplest and the most basic definition you can give for you to so that it's easy for you to identify. Now it's important that these guys act within the limits. Now example, I give her some powers. Okay, say that it's a lecturer here, and I mean going back to school, the lecturer or the teacher makes her the class monitress, right? And she has certain powers, right? So she has to exercise it within the framework given to her. She cannot be hitting people, she cannot be like doing things as per her own wishes, whims and fancies, right? She has to do it according to the powers given by me or the lecturer, the teacher, and the teacher and the lecturer would have like some sort of control. How are we having control? Is through the judiciary, right? Because technically now then government එකක් ගත්තම or public body එකක් කියන්නේ government එකේ තියෙන wings දෙකක්, the politicians and the bureaucracy, the ones who actually do the things, like executive they are the ones who actually implement, right? So I mean if I'm now parliament, if I'm like the government say that I cannot be looking after my own people more or less. So because of it, what we do is we let the judiciary, like a third party, to get involved and to solve the problems of my followers. Let's put it in a very simple way, right? So ඒක තමයි administrative law එකකින් කරන්නේ. So that's what ultra virus is. Now ultra virus is of two folds. That's substantive ultra virus, that's procedural ultra virus, right? What is it again? Substantive and procedural. So it's easy if you can like draw like a dichotomous key. උඩ දාලා ultra virus කියලා දෙපැත්තට ලියා ගන්න substantive and procedural කියලා. මම දැන් කියන්න, you all know the difference between substantive and procedural, right? So just to like add more clarity to it, substantive කියලා කියන්නේ now say okay I don't like her, right? So what I do is, and I'm a department again කවුරු head කෙනෙක් or like I'm some official, what I do is I kick her out simply because I don't like her. That's the only reason or the explanation I can give. So like there is something, so this wrongdoing renders the act illegal. I mean I can't just fire her just because I don't like her, right? And it makes it illegal plus like null and void killing. There's no legal authority for me to do that. But okay, second instance, that is substantive. Now second instance is, now she has done something wrong, right? I don't like her, which is a different story. But I'm supposed to, if I'm firing her, I should give her the chance to be heard, right? Now she has done something wrong, I'm convinced, you're convinced, all of us are convinced. And we kick her out. Procedurally ultra virus, or that I'm acting without power. Why? Because I can't kick someone out without following the due procedure, right? So that's the difference between substantive and procedural. Okay, so you need to know two cases actually, right? The first case is GCHQ case. I'll give you the long title of it. Council of Civil Service Union versus Minister of Civil Service. Okay, so මේකේ වෙන්නේ, now this case is very very important because that's when like people really stop to think hari මෙහෙම division එකක් තියෙනවා සහ මෙහෙම concept එකක් ultra virus කියලා තියෙනවා කියලා. GCHQ case එක. So just the case facts in brief. Minister of Civil Service banned employees of the government communication headquarters from being members of trade union. Decision was not declared invalid as fear of industrial action to disrupt the sensitive intelligent works relating to national security. So this was like, way back. Now, there's a case of Wednesbury. Associated Picture House Limited versus Wednesbury Corporation, Lord Green. Hari? So, now GCHQ case plus the Wednesbury case together lays the important grounds of judicial review. As I said before, අපි දැම්ම substantive ultra-virus and a procedural ultra-virus කියලා, right? So under substantive ultra-virus, there's illegality and irrationality. Okay? There's illegality and irrationality. And under procedural impropriety, that's procedural impropriety. Sorry, procedural ultra-virus, then under that, there's procedural impropriety. I'll explain every single limb and then illegality අතරේ illegality බෙදනවා තව කොටස් පහකට වගේ. Right, so we'll discuss all of that. Would you want me to slow down or would you want me to fast forward? How's the pace? Okay, now is okay. All right. ඊට පස්සේ then I told you law is an ever changing concept. To understand law is to look at it in a very practical sense. So when you look at it practically, or when the judges looked at it practically, they also realized that මේ illegality, proportionality and procedural impropriety වලට වඩා දෙයක් තව තියෙනවා කියලා. What is that? Illegality, irrationality and procedural impropriety වලට වඩා දෙයක් තියෙනවා කියලා. What is that? Proportionality. Now this is a developing concept, right? Okay, so before that, so there are certain, as I said before, when you write a particular answer, your answer, how you look at it, would differ from hers, right? So that's the beauty of law, where you sort of, can develop your own answers. Similarly, the scholars in this area is also divided as to how exactly, right, this division occurs. Like example, then procedural ultra-virus, substantive ultra-virus කියලා දෙකක් තියෙනවා. ඒක everybody agrees, right? But then again, ඒක ඇතුලේ තියෙන elements ටික the scholars are disputed. So last year we referred to a book called it's a London LLB book. LLB කවුරු ඉන්නවද මෙතන? admin law කරපු the Barnett, right? So Barnett එකේ තියෙන classification එක වෙනස්. මේ tute එකේ තියෙන මේ Justice Nawazගේ tute එක. So, but last year it was a little different because the paper was also a little different, right? So, Ekanisa, I suggest that we go according to the classification in Justice Nawaz's tutes or his lecture slides when he was a lecturer here. So, a classification I'm just telling you all, in case your lecturer has taught like a different classification. Have you all gone to lectures? Is it the same classification? Okay, great. Same. Okay, then we are good. Hari. So illegality. Okay, so I'll first of all read the statement from the GCHQ case by Lord Diplock. ඊට පස්සේ I'll explain the statement and I'll also show varying degrees of this concept of illegality. Okay, are you following me? Are you following me? That's my biggest fear, that people don't understand what I'm saying. තේරෙනව නේද? Okay. Right. Lord Diplock says, I mean that decision maker must understand correctly the law that regulates his decision making power and must give effect to it. If the decision maker misunderstands the law, it is illegal, right? So technically what happens is, I'm supposed to give a decision, and for me to give the decision, I don't understand the law. I don't understand the law that's backing this decision. So what I do is, I could be genuinely mistaken as to the decision I'm making, right? But nevertheless, the decision is wrong. It's null, it's void, and it's illegality, so, right? So illegality වල තියෙනවා main concepts තුනක්. There are certain instances where I'm acting without power. I don't have power, I'm acting without power. Simple, no? And second is acting excessive power. Now the difference between these two is, say that right, okay, again the whole class monitress's example. Now I have power, I'm the class monitress, I have power in the class, right? But එළියට ගිහිල්ලා I cannot be, commenting on like other people's hair, uniform. That's up to the prefects to do, right? So I don't have power, but I go make havoc there, or like I do something very unreasonable, and so that is an example, acting without power. Acting excessive power, now I'm the class monitress, I have certain powers to like, tell you all to do certain things, but I don't have power to hit. Acting excessive power. And abuse of power, right? Now the beauty, again, the reason why a lot of people find admin law confusing is because all of these sound the same. Trust me, 2 days before the exam or a day before the exam, like for me, it all sounded the same, right? As students, I think it happens. Again, the good thing about law is it's all about how you explain. It's all about how you support, because admin law වල තියෙන scenarios නේ දෙන්නේ. At least I think the paper I wrote, we had scenarios. Have you seen a paper? Last year paper දැක්කද? Yeah, scenarios, right? තිබ්බේ ගොඩක්. So scenarios වලදී, I mean, again, it's how you support the answer, right? So don't worry just because it sounds very confusing and all the same. Bye වෙන්න එපා, right? So abuse of power. Now, okay, we'll go back to the dichotomous key that we've been doing. Chart එකක් වගේ අපි හැදුවේ. There's ultra virus, substantive ultra virus, there's procedural ultra virus. Substantive ultra virus divides into illegality, right? As well as, come on, help me out, I've forgotten. There we go. Can you like tell it out loud? That's the thing, right? So illegality divides again into 3. Acting without power, acting excessive power, abuse of power. Okay? No worries. Abuse of power divides again to 5 other categories. So that's why I said dichotomous key එක ඇඳගන්න. ඒක ඇඳගත්තා කියන්නේ even like say that you're familiar with that dichotomous key, you understand everything. So the day before the exam, a few hours before the exam, ලොකු කොල එක මම ඇඳලා තියාගන්න. ඊට පස්සේ you can also write the cases underneath all of it. One sheet of paper you can study in and out. About 2 questions you can finish, or you can do it very well, right? So always there's no point of you studying so hard, like judgments 500ක් කියවලා, going through 100 or different textbooks. No point if you can't put it in to a single sheet of paper within 2 hours, because you're not getting 5 hours to write the answer, you're getting just 2 hours to write 6 answers, right? So it's very important that it's muscle memory. When you sit there, you see it and you know what to write. Simple. That's why I say it's not rocket science. Law is not hard. See, there's a reason why we are doing law. This is a joke, okay? By the way, this is a joke. Not serious. See, a friend of mine was saying that the reason why we do law is because we are bad at maths. Because for maths, you need to know certain things. For law, you don't have to, right? But the thing is, the beauty of law is again, like there's something more to it than maths that makes you, fall in love and whatnot. Right. So the 5 subheadings of abuse of power, or 5 like different headings of abuse of power, is improper motive. You abuse power because you have an improper motive. That's bad faith, right? Improper perks, the whole, getting bribes and all of that. You have improper perks. Acting contrary to policy and objective of statute, right? Then there's fiduciary duty. Hi? I'll repeat it again because I think I was a little fast. Improper motive, bad faith, improper perks, acting contrary to policy and objective of statute, fiduciary duty. Okay, so that 4th category again divides into 2. Delegation of discretion, improper purpose. That fourth category කියන්නේ acting contrary to policy and objective of statute කියන්නේ. අනේක තව දෙකකට බෙදනවා. Delegation of discretion and improper purpose. There's no marker pen, no? There's one. No, that's it. Yeah, thank you so much. So I'll write it quick. I'll write it on board also, so it's easy. Shape. Okay. So the first limb is acting without power. Very simple. A public authority acts without power, or a public authority lacks power to make a certain decision, or like to make certain calls, to put it very simply. The case is Narandini versus Export Development Board. Right. So මෙතන වෙන්නේ මොකද්ද? Export Development Board එකේ director කෙනෙක් or deputy director කෙනෙක් appoint කරන්න නම් it has to be approved by the board, right? So what happens in this case? Appointment was made by the chairman, right? And then it was said that it's illegal because he has no power to confer powers to that deputy director or to make that appointment in the first place, right? So the Court of Appeal issued a writ of certiorari to quash that appointment. Now guys, see, the chairman would have genuinely believed that this guy is suitable for the job, like genuinely believed, but the thing is he doesn't have the power to do it, so the appointment he makes is illegal, right? Then there's again the case of White and Collins versus Minister of Health, where a minister went and acquired a private park. Now the minister under that particular statute, or like certain like chain of command, he doesn't have the power to acquire such a park, hence it was held illegal. Now acting in excess of power, that's the second one. Now public authority is given power to do one thing, right? But instead of that, the public authority, the public official goes and does another thing. Sounds very familiar, no? So the case is Attorney General versus Fulham Corporation. Okay, so the Bath and Washers Act, this was in England. It grants power to local authorities to run municipal bath and wash house, where you basically take your clothes, right? You wash it on your own. So instead of that, what these guys did was they opened a laundry, right? Small thing, no? I mean, wash house at දාන එකයි laundry එකත් දාන එකයි, one would think like it's all the same, but it's not. So because of it, they were said to have acted in excess of power, therefore illegal. Rex was a Secretary of State for Home Department, ex parte leash. The case of leash Riaganda. I'll just quickly go through it because I mean you get the principle and it's just a matter of knowing the case facts of each case. Prison rules gave power to prison authorities to record and circumvent letters from the prisoners to check whether they are bona fide for security. Letters from to prisoners and solicitors did not come within the scope, and checking them is in excess of power. I mean, I can write, if I'm in prison, I can write a letter to my mother, and that letter would be cross-checked by the prison authorities, right? Or I can also write a letter to the solicitor, right? But those letters cannot be cross-checked because that's private and confidential information. So I have power, I mean the prison authorities had power to check my mother's letters or my letters to my mother, but not my letters to the solicitors. Mixum Property Limited versus, I don't know how to pronounce it, so write it down. CHERTSESEY, Urban District Council. Okay, so again, the council had power to run a caravan site, but they didn't have power to formulate contracts for such caravans. So they have acted in excess of power, right? Actually, guys, here if it's taking your time and you have like better things to do, I have no worries. You can leave anytime, so no issues at all. Right. So then we'll move on to abuse of power. So a public authority abuses his power and perform an action. Improper motive is you have like an ulterior motive, and hence why you're performing a particular action when you in fact don't have power to be doing that action, right? So Municipal Council versus Sydney versus Campbell, power to compulsory acquire land for improvements of the city, held acquiring of a land for the purpose of benefiting anticipated increase of value is improper motive. Okay, so technically would you want me to explain that? Confusing deka? It's okay. Okay, so nonetheless I'll go ahead because I'm just not sure that some of you got it. Now the public authorities, or even in Sri Lanka, the government can acquire certain lands, right? Now abuse of power, when these guys went and acquired a land, they have power to do it. They are not acting without power, in excess of power, nothing, right? They have power to do it, but the only reason why they did it was to make sure now property prices rise, no? So a increase එකෙන් benefit එකක් ගන්න. So අද මං ගිහිල්ලා මේක acquire කරනවා, right? හෙට වෙනකොට maybe I can sell it to somebody because the property prices have increased, and that was the only reason why I went and acquired that land. So that's, now it's important to realize the difference between acting in excess of power and abuse of power, because එක වගේනේ ඇහුනම in excess and abuse. What's the difference? In excess වල වෙන්නේ you don't have power to do it, but you nevertheless go and do it, right? Abuse of power is you have power, it's not out of your reach, nothing, just that you have like a very improper motive backing it up. Bad faith, right? So in Wednesbury case, Lord Green says a decision could be quashed on the basis of having been made in bad faith or dishonesty. So bad faith කියන concept එක establish කරේ Wednesbury case එකේ. Secondly, in the case of Cannock Chase District Council versus Kelly Megaw, MEJAW. Sorry, Megaw Lord Justice is a judge who said this. That's my bad, sorry. Bad faith or dishonesty, not necessary for financial motive, but still dishonesty, although taking no into consideration of a fact which is in law relevant. So you need not have financial motives for it. You need not be benefiting financially out of it, benefiting in some way or the other, and using that reason or with bad faith making a certain decision is still illegal, right? Yeah, I'll just keep those two cases. If you want, you can ask for the cases from me. I have like few short notes also, not mine actually, because my short notes I think I gave it to somebody. If you want it, you can ask from me. All the cases are there because you only have like another hour and we have a lot to do. I'll just keep that case. If you want, just let me know, okay? Right, and then we come to acting contrary to policy and objective of statute කියලා. ඒක තව දෙකකට බෙදනවා කියලා කිව්වේ. Delegation of discretion and improper purpose. Now we come to that. We'll first of all talk about delegation of discretion, right? And then we'll move on to improper purpose. The case is the case of Padfield. Okay, so very simple. This was again in England, the Agricultural Marketing Act. There was an act called the Agricultural Marketing Act, and this provides power to ministers to solve disputes of milk marketers, right? Now the minister is provided with that particular power. What the minister does is he forms a board. Under him, he forms a board and says, look here, I have better things to do, so why don't you all take care of this? And the board made a decision, right? And they said, no, you can't do that, or rather compel the minister to act according to the statute. That is, for him to take care of it without conferring that power to a board. Okay? Then we move on to improper purpose. Parliament confer particular power to a specific person for a particular purpose as expressed in the statute. If we act accordance with the statutory purpose, it will be lawful, otherwise illegal. Right? So improper purpose is actually a little bit similar to what we discussed before. Improper motive, right? But the difference is that you are conferred power through a statute, right? Okay, so we move on to improper perks. Improper perks. Again, just one case. Rex versus Secretary of State for Home Department, ex parte Fire Brigade. Power conferred to the Secretary to place a compensation scheme for criminal injuries. Introduce radically different scheme for compensation for another context is abuse of power. So you are given power to power is conferred to the Secretary. I'm the Secretary, I have power to introduce a compensation scheme for what? For criminal injuries, right? I go and introduce a compensation scheme for something else. Maybe say that for spouses of the ones who are criminally injured. Doesn't work. Or to health scheme mama introduce karna. Still doesn't work, right? Then we go to the final bracket or final category for the first limb, that is illegality. Again, remember, no? Substantive ultra vires, procedural ultra vires, under substantive only අර තුන එන්නේ. ඒ තුනෙන් අන්තිම එක divides into 5 again. The fourth limb of that divides into 2 again. We're talking about the fifth limb here. Okay? I'm so sorry, Thiru. Tell me if you don't understand when I talk in Sinhala, okay? Local authorities on fiduciary duty. Local authorities collect money from tax to fulfill its statutory duties and provide essential services to the public, right? The local authorities owe fiduciary duty to those from whom tax is collected and not spend them thriftlessly, right? But to provide service or benefit for community. If they fail to do so, it would be abuse of power, which render their decisions illegal. Example, okay, now we pay taxes, no? Your beloved local authority, without fixing the road right in front of your house, right, goes and builds some monument for somebody we don't even know who hasn't really contributed significantly. They have a fiduciary duty to make sure that they first of all fulfill, the requirements of you. They cannot be spending money thriftlessly. They cannot be spending money as, they brought the money themselves, right? So that is what you know as fiduciary duty. Now we'll move on to irrationality. Before that, just take some time, go through everything and tell me whether you understand what we've been talking about all this time, okay? You just want the headings? You want the headings, or would you want me to explain each aspect? Okay. Improper motive, bad faith, improper perks, acting contrary to policy and objective of statute. That is divided into two: delegation of discretion, improper purpose, right? And we come back to like the original now. I've told you four, no? The fifth is fiduciary duty. Okay? Sorry? Proportionality is a developing concept, right? I told you that now now scholars of this area is also divided as to where it falls, right? So for now, proportionality is there as an independent element again, right? So I mean, again, in an administrative action, it doesn't really matter whether it's substantive, the procedural, the hearing. So long as like it falls within one of the limbs, you can.
So it still comes under ultra-virus, right?
Yeah. It comes under ultra-virus. There's no, I mean, it doesn't fit in specifically to say that it's substantive or procedural. That's the difference. Okay. So irrationality, like the word itself says, it's irrational to do it, right? Again, if you want, you can quote. Now, if you quote certain, quotations, of course, the lecturer would know that you read the book, or at least, attempted to read the book. Okay? So maybe if you want, you can jot it down, or you can just ask for the quote from me. It is a decision which is so outrageous in its defiance of logic or of accepted moral standards that is no sensible person who have applied his right mind would never arrive. Neil Papworth, again I don't know how to pronounce his name. It's P-A-R-P-W-O-R-T-H, Constitutional and Administrative Law, page 291. Okay, so this case, R versus Ministry of Defense, ex parte Smith. You can just write this as the case of ex parte Smith. So in this case, what happened was there was a policy, right? There's a policy in the Ministry of Defense that people, who engage in acts of homosexuality should not be given leave to perform certain acts of the army, right? And what happened was, so the military actually discharged certain people from the army because they were homosexual. And then the courts decided the decision to, so this particular case of course say that the decision to discharge them is not irrational, right? But what we are trying to get at is here the fact that now the Ministry of Defense had a policy, and it was under that policy this happened, right? So because of it, because of it is justified to a certain extent. But again, I have my doubts about this case. So I'll quickly clarify the final judgment of it, okay? Because I'm just not sure that it's right. Appeal Act I'll clarify and let you know. For now, just remember, if it's irrational in the sense, nobody who would say that you have like a particular phrase, you read that phrase, right? And you arrive at a decision that is so far-fetched that nobody in the right mind who have read that phrase would have interpreted that phrase or that policy to be the same as you've interpreted. Okay? So that's what irrationality means. I'll check and let you know. Or are you all able to find the case of ex parte Smith? Can someone read me the final judgment of it? ex parte case එක කවුරු ළඟ තියෙනවද? In the union note එකේ නැද්ද? Okay, until we look for that, we'll move on to the remaining because අපිට තා චුට්ටයි තියෙන irrationality ඉවර කරන්න, and maybe we can move on to like the procedural aspect of it. Okay, so irrationality, that's what irrationality means. You have to quote the case of ex parte Smith. The important point that you need to harp of irrationality is the definition of irrationality, because irrationality බෙදනවා තව දෙකකට. අර dichotomous එක ආපහු ගහන්න ඕනේ. So the importance is that you harp the fact that a person in a right state of mind would have never arrived at the decision the public officer arrived at, right? Therefore, it is irrational. Okay, so irrationality is divided again into failure to exercise discretion and abuse of discretion. Irrationality again into two: failure to exercise discretion and abuse of discretion. Failure to exercise discretion is divided again into four: acting as though limited by external rules, fettering of discretion, decision maker apply policy without flexibility, unauthorized delegation of discretion. Okay guys, the ex parte Smith case, it wasn't a typing mistake. So it was, so they decided that decision to discharge them is not irrational. I'll tell you why. Now, as I said before, there was a policy. So the policy කියන්නේ parliament එකෙන් pass කරපු policy එක. So that gives power to the officers or like the officials of the army to make certain decisions. So as a result of power conferred to them, right, they made a decision to let go of people with a homosexual origin, right? That's what they did. Now, agreed that the whole the policy may be irrational. And remember, this was like, you know, some like good 100, not 100, but 50, 60 years ago, right? So the policy may be irrational, but the public officer acted under the direct directions of that policy. So the decision he makes is not irrational. Okay? So it's not outrageous or like it's not illogical for that person to come into that conclusion and make that decision, because that's simply what he was told to do. Okay? Right, so moving again, coming back to like where we were. Okay, so in the dichotomous key, now you put two, no? So under that, under the first, that is failure to exercise discretion, the first category, acting as though limited by external rules. So what happens here is, I'm not exercising my discretion thinking that I'm bound by certain external rules, right? And because of it, I don't exercise it. I don't take the decision at all. But in fact, I'm supposed to, right? Irrespective of whatever the external rules, you know, probably my moral upbringing or whatever, irrespective of all of that, I'm supposed to act in a particular way, but I don't act in that way. This is also described as surrender of discretion or acting under dictation. Okay, so the case is Rex versus Stephanie Corporation. Okay, so what they do is, or what rather this Stephanie Corporation, this public authority, what happened was, the corporation was supposed to, or rather abolished compensation after consultation with the treasury, thinking that they're bound to obey treasury practices.